And do I have Ms. Rael here, Luann Rael? All right, this is 25T84. I have Ms. Rael appearing in person today in the courtroom. I have Mr. Barnett at the District Attorney's Office. We sent this matter over for a pretrial readiness conference. We were set for trial on March 12th at 8 a.m. Ms. Rael, I see that you're still representing yourself in this matter. Is that correct?
I would like to invoke my right to remain silent.
All right. Mr. Barnett, anything from the state we need to take care of?
No, Your Honor.
All right. We're set for jury trial on March 12th. And we'll come back one more time for a pretrial readiness conference. I did issue a case management order in this case on November the 3rd. Ms. Rael, you are required to comply with that case management order. I do want to ask you a couple of questions just to make sure you understand that you do have a right to represent yourself. I understand that you've typically just stated that you wanted to exercise your right to remain silent, but I want to go over this with you. You understand that the allegations that you're facing are up to a Class 1 traffic offense, which is up to 364 days in the county jail. That is the maximum penalty on that charge. How much education do you have, Ms. Rael?
I would like to invoke my right to remain silent.
All right. Do you understand that there are legal complexities in this case that ultimately that even though you're representing yourself, that you're going to be required to, under the same standards, rules of evidence that the district attorney would be under. Do you understand that? Do you understand that, Ms.
I would
Rael?
like to invoke my right to remain silent.
Ms. Rael, this has nothing to do with your innocence or your guilt. I'm trying to determine whether or not you're capable of even representing yourself. I've been very, very patient with you. You haven't even stated your name. I'm not even quite sure that you are Ms. Rael. I called Ms. Rael to come up here and you stand up here. And so I'm basing on that an assumption, I guess, that I'm making. But I have to establish certain things to make sure that you understand what you're faced with here. You have a right to remain silent of anything that might implicate you in any sort of criminal activity, whether or not you've gone to schools that are making it. It's called an Arguello advisement, is how we refer it to. It's to make sure that you understand that I know that you're competent to represent yourself. Do you want to represent yourself in this matter?
I am invoking my right to remain silent.
All right, I'm going to take that as a yes. You understand, obviously, you have a right to remain silent. Finding that you can represent yourself in this matter. We're going to go ahead and continue on with the jury trial. We'll set this for one more pretrial conference. Mr. Waldo Mr. Barnett.
And I do not understand.
Before we even get into the chaos you're about to witness, let me prepare you for what this courtroom is about to turn into. Because this isn't just one case of someone misunderstanding the law, this is a masterclass in sovereign citizen delusion colliding headfirst with reality. Today's video features not one, but two different defendants who genuinely believe that repeating certain phrases, refusing to answer basic questions, and accusing judges of speaking Latin somehow grants them immunity from the legal system. And spoiler alert, it absolutely does not. In the first case, we meet Miss Luann Rael, a self-represented defendant facing a jury trial who claims to be invoking her right to remain silent, while simultaneously refusing to stop talking. This is where things get dangerous because judges are legally required to make sure someone is competent before allowing them to represent themselves. And when someone refuses to answer even the most basic questions, that becomes a real problem.
First of all, you have put me in a compromised situation. I do not speak Latin.
Okay.
I do not know the Latin language. Am I in your commercial jurisdiction?
Ms. Rael.
Or,
okay.
let me speak.
Okay, if you want to speak, yeah, go ahead.
Am I in your commercial jurisdiction? Are you going to give me an interpreter? I still do not understand. I don't know what's going on. My freedom is at stake. I have the right to counsel. My freedom's at stake. You charge me a fee. You separate common law to my freedom with commercial law, where you impose a fee on me.
All right, so Ms. Rael, I'm going to interrupt you. Ms. Rael.
Both ways.
Ms. Rael, I'm going to interrupt you now. So do you,
Which
Ms.
jurisdiction am
Ms. Rael, if you don't stop, I'll hold you in contempt and I'll put you in custody. Stop. You clearly understand the English language, and I'm speaking to you in English. Do you need an interpreter in another language? Because I'm not speaking in Latin. I'm speaking in the English language. You just stated to me that you have a right to counsel. Would you like an attorney appointed to represent you?
Can I finish speaking? Can I finish speaking?
What do you need to say, Ms. Real?
Okay, then I am invoking my right to remain silent. If I cannot speak, then I am invoking my right to remain silent.
Then what would you like to say?
I'm trying to say it, you're not allowing me.
This right here is where the irony becomes painfully obvious. Miss Rail keeps invoking her right to remain silent, but what she doesn't understand is that the judge isn't asking questions to incriminate her. He's trying to determine whether she is competent to represent herself. That's a constitutional requirement. Judges can't just let someone go pro se without confirming they understand the risks, the rules of evidence, and the possible penalties. Refusing to answer questions about education or comprehension doesn't protect her, it actually hurts her position. The court needs to know if she understands what's happening, and silence in this context isn't a shield, it's a red flag. This is a classic sovereign citizen tactic. Misuse legitimate constitutional rights in situations where they don't apply, then claim victimhood when the court pushes back.
So if you have questions or understanding of the court, but I'll give you a couple of minutes to complete whatever it is you wanted to say, but we're not at trial at this point. I'm trying to just determine whether or not you understand what's going on. Would you understand the English language? It's very clear to me that is the case. And I'm not speaking to you in Latin, Ms. Real.
Am I in your commercial jurisdiction or am I under your common law jurisdiction of the Constitution? You compromise me in every single way when I come into the courtroom. You strip me of my right to bear arms by running me through a metal detector, already compromising my rights as an American. You force me into a room where you have sentries with body armor, guns, pepper spray, tasers. You sit me down in a chair and then you ask me if I understand. No, I do not understand. You violate me through and through, and then in the middle of the game, we get halfway through the hearing, you change it, and then you spark out some word in Latin, and I am sitting here confused as all heck, asking me if I understand. If I don't put up and tolerate with your actions, you will have your officer standing up against the wall, pull out his weapon to scare me and throw me in a dog cage. You are acting criminal, corrupt, and evil and demonic. I do not understand, and therefore you cannot form jurisdiction over me. You speak a foreign language that is regulated from Britain.
Okay,
in
Ms.
America,
Real, that's
in
enough.
America, you
Ms. Real,
speak English to me.
Ms. Real, that's enough. I've heard enough. Okay, so you obviously understand the English language. Okay, so you are under the jurisdiction of the court. That is the jurisdiction that you are under. You are in the Conejos County Court. I am the Conejos County judge, and I do have jurisdiction over you.
Can I finish?
No, you cannot. I'm not going to continue to listen to this. This is what we're going to do. You are set for trial on March 12th. You will show up here for trial on March 12th. If you don't show up, I will issue a bench warrant for your arrest. We are going to have a trial March 12th. You have the right to counsel. If you would like to apply for counsel, you clearly understand that because you just told me that you have a right to an attorney. There is an application right there on that table. You can fill out that application and you can provide that to the public defender's office. They can enter an appearance for you free of charge if you qualify. That is your right to an attorney. If you don't want to apply, and that's absolutely your choice, you get to elect that. But we are going to trial on March the 12th, and you will be here for trial on March the 12th, and we will put it to a jury, the allegations against you. That is what we're going to do.
Okay, well then, can I get that in writing?
You have it on the record. We'll be here March 12th for a trial.
What time is that?
Start at 8 a.m.
All righty.
We won't need to come back for another pretrial conference, Mr. Barnett. We'll be here for trial March 12th.
Thank you, Judge.
And here we go, the moment where logic completely leaves the building. The claim that the judge is speaking Latin is one of the most common sovereign citizen myths, usually tied to the belief that legal terms somehow transform English into a foreign, binding spell. But here's the reality. The judge is speaking plain English on the record with clarity. This tactic isn't confusion, it's deflection. When defendants feel cornered, they pivot to manufactured misunderstandings in hopes of derailing proceedings. Notice how the judge gives her multiple opportunities to clarify, even offering an interpreter. That's not oppression, that's patience. And when someone refuses every lifeline offered, the court eventually has to move forward without them.
All right, court's going to call case number 23 CR 884 People versus Michaela Mayberry. I'll take entries. I'll start first, Ms. Becker, with you.
Amanda Becker for the people.
All right, and I note this matter was set at 1 p.m. for a motions hearing. It's currently 1:03. Ms. Mayberry does not appear. I'm going to give her to 1:05, and then we're going to move forward. Ms. Becker, can you remind the court, has there been any failures to appear in this case?
Your Honor, I was just looking at that. We did have ones early on, and she did have to be extradited from Texas. But she has been since on bond and in Colorado and appearing for the last several. Our last FTAs weren't since August of 2023. She also has a revocation matter in Adams County. She did appear at their last hearing in October of 2025. And then I just checked Vine Link and she does not appear to be in custody.
Okay.
I think give her to like 115.
Okay. All right, we'll wait 10 minutes. All right, we're back on the record in 23 CR 884. I'll note for the record that it is now 1:20. This matter was set at 1 p.m. Ms. Mayberry does not appear.
Given that there was the older FTA, the age of this case, and that we have had to extradite her from Texas, I do think the 20,000 cash surety is appropriate. She also has somewhat of criminal history for VPOs primarily and some other trespass to dwellings. So also a history of not complying with court orders, which is also why I'd asked for the 20,000 cash surety.
All right, what the court's going to do, I'm going to find that Ms. Mayberry has failed to appear. I'm going to revoke her bond. Court's going to issue a warrant. Court will set a new bond in the amount of $20,000 cash or surety that is based on Ms. Mayberry's prior history of failing to appear, as well as her criminal history and the severity of the underlying charges in this case. We'll maintain our trial dates, and I think we need to see when Ms. Mayberry is picked up and go from there. All right, we're going to set this over for Thursday at 1 p.m. 1 p.m. Ms. Mayberry, you need to be there right at 1 p.m. Court's going to call at 1, and we're going to move forward. Court will quash the warrant that was previously issued. Ms. Becker, is there anything else? Any discovery updates?
Thank you. Your Honor, I did want to alert the court. I did provide Ms. Mayberry a copy of all of the discovery in this case today via a USB. I also had her sign a document noting that she's received that discovery. It does have all of the both media and the PDFs in this case. I did also get a good email address for her today. So if there are any trial preps that create potentially new discovery that we usually create around trial preps, that would be the only thing we would be emailing her new. Otherwise, all the discovery is in. And then lastly, the people did just want to make a brief Lafleur record.
Yeah, please go ahead.
Thank you. Ms. Mayberry is charged with a Class 3 felony for burglary that has the possibility of 4 to 24 years in the Department of Corrections. It is, we do consider her enhanced due to a case being open at the time, which is Adams 20 CR 4209. That's what makes the enhanced range 4 to 24 years. She is still probation eligible, even if convicted at trial. The offer on this case was to a Class 4 felony for burglary in the second degree and a Class 5 felony for palpo, which is possession of a weapon by a previous offender. That is also the enhanced range with the possibility of 2 to 12 years and is still probation eligible.
Okay. Ms. Mayberry, do you have any questions about that?
Just the verbiage,
Okay. What part of the verbiage?
all of the verbiage of it.
So let's, I guess, break it down then. Ms. Becker, the offer is to,
It would be for a slightly lesser felony. It's still called a burglary in the second degree, but it's one step down. That's why you go from a 4 to 24 range to a 2 to 24. And then a Class 5 felony for palpo, which we would, if she was sentenced on both the F4 and the F5 palpo, we would ask for a sentence together in that range of 2 to 12 years.
okay. And the palpo is possession of a weapon by a previous offender. So if you proceed to trial, the potential sentencing range that the court can impose is 4 to 24 years. The offer is a plea to a charge which would set the sentencing range from 2 to 12 years. Okay? Because we're proceeding on this case, the district attorney is making this record because there's not going to be any further offers. We're going to proceed to trial on this case. Do you understand that?
Yes, Your Honor.
Okay.
The people don't object to a bifurcation. I do think that makes sense to do the Palpo and the VPO after the other two charges. And for defense 8 for the motion to eliminate, the people would not be presenting Ms. Mayberry's prior criminal history unless she were to testify at jury trial.
All right, we're back on the record in 23 CR 884. I'll indicate that Ms. Mayberry is present. Ms. Mayberry, you were late today. What happened?
I'm
You
sorry?
you were late today.
5 minutes?
Yes. I told you on Tuesday that I wasn't going to have you late for today's hearing. You
Well,
need to be on time.
I have to take public transportation, Your Honor.
I told you about this hearing on Tuesday. You could have made arrangements to be here on time.
And yes, I did.
And you
Got
were
here
late.
As soon as I could, Your Honor.
Okay. What I'm going to say, Ms. Mayberry, we're set for trial. If you are going to be late for any of those trial dates, I'm not going to keep the jury waiting for you. I will remand you into custody for the trial if we need to do that to make sure that you are here on time. Okay? We have people waiting. You need to be on time. We're going to go forward. Ms. Becker, we're going forward on the defense's motion to suppress show up identification. Are the people prepared to proceed?
Yes, Your Honor.
All right. The people can call their first witness.
This is where the sovereign citizen ideology fully takes over. The references to common law versus commercial law being compromised and metal detectors violating constitutional rights are all recycled talking points that have zero legal standing. Courts have repeatedly ruled that jurisdiction exists based on geography and subject matter, not personal belief. What's especially important here is the emotional escalation. She frames routine courthouse security as criminal abuse, turning standard procedure into a persecution narrative. This isn't just misinformation, it's dangerous thinking. And judges are trained to recognize when rhetoric crosses from confusion into obstruction, which is why the judge cuts this off decisively.
I'd kind of like to direct you to April 5th, 2023. Do you recall getting a call out for this case?
Yes, it was a general call for service.
And are you aware that there was a 911 call that kind of preceded that call out?
Yes, it was a 911 call for a burglary in progress is what it was coded as.
And did you review the 911 call that was involved in this case?
Yes,
And when you listened to that phone call, did you recognize the voice of the caller on that call?
yes.
Who was it?
Felisa, the homeowner that I eventually contacted in this case.
Your Honor, the people would move to admit People's Exhibit 1, which is the 911 call in this case.
Ms. Mayberry, do you have any objection to People's 1?
No, Your Honor.
All right, People's 1 will be admitted.
No, what is the address of your emergency? Stay on the line, okay? This is Jeff. I'm with the transfer. It's gonna be 9665 West. I'm just gonna spell it. David, Adam, Nora, Zebra, Ida, George, Place. What's going on there? I walked in on a robbery at my house. Okay. They walked into your house and there was a female inside your house? Yes, they broke into our gun safe. They take any of the guns? I think so. I ran out of the house. I'm sorry. That's okay. Take a deep breath for me. Did you see them leave your house? Yes, she went through the front door. And you said that they did take the guns? I think so. I ran out. I didn't look to see, but she was in the gun safe. And I don't think there's anything left. Was it just one person? I saw just one person, yes. Just one. The female, can you tell me, was she white, black, Asian, Hispanic? Asian or Hispanic. And she had on all white clothing? Yes. Okay, and there was a white hoodie, you said? Yeah, some white pants. Okay, it's okay. When you saw her, did she have any weapons in her hand? No, she was holding my son's Xbox. Okay. But she was in my office in the gun safe.
On that call, did the victim indicate if the person was a male or a female?
Female.
And how did she describe her race?
Hispanic or Asian is what she described it as.
And how did she describe what the person was wearing on their face?
An M95 mask,
Okay. And did she describe what the person was wearing?
all white.
Thank you. And that was with a hood?
Yes.
Okay. And did she also say that she was thin-billed?
Thin billed, yes.
Thank you. So after that point, where did you transport the victim to?
Hogback Hill Park, which is where my officers had detained the person that matched the description given.
How far was that from the house that was burglarized?
It's a few blocks, not very far at all. A drive less than 2 minutes.
Would it have been within walking distance?
Yes.
And where was, when you kind of got on scene for that show up, can you describe where was the suspect?
Sure. The suspect had been taken out of the patrol car, was standing next to the patrol car with my 2 officers that were on scene, and approximately 20 feet from where my vehicle eventually stopped for the show up to occur.
Were the 2 officers next to the suspect in uniform?
Yes.
And you said it was a patrol car. Was it a marked patrol car?
Yes, marked unit.
Was the suspect detained in handcuffs?
Yes.
And were you wearing body-worn camera on that day?
I was.
And was it working correctly?
Yes.
Have you reviewed that in anticipation of today?
Yes.
Your Honor, the people would move to admit People's Exhibit 2 and just do a 1-minute clip from officers' body-worn camera of that day.
Any objection to 2?
No, no, Your Honor.
Ms. Mayberry, I'm not sure you're appreciating the serious nature of this. You need to be off.
This is the turning point. The judge clearly states jurisdiction, authority, and consequences. No debating. No philosophical arguments. Just facts. And this is exactly how courts handle sovereign citizen theatrics. They acknowledge the statements, reject the nonsense, and move on. The warning about a bench warrant is critical. Too many defendants think court dates are optional. They're not. Once a trial date is set, failure to appear turns a bad situation into a worse one instantly. At this moment, Miss Rail still has options. Apply for counsel, prepare a defense, and show up. Whether she does that is a different story entirely.
I will move to publish People's Exhibit 2, which is a clip of 1850 to 1921.
You can go ahead.
So I just have to ask you these questions. Do you recognize the person you viewed?
Yes.
Okay. If so, from where do you recognize them?
My office, my house.
Okay. And are you confident, somewhat confident, or not confident at all?
Confident.
Okay.
And then how did she indicate that she knew her from?
From in her home, in her office.
Thank you. There was somebody else on that clip. Who was in the car with you all?
Her husband, she had requested that her husband go with us. She was greatly distressed and had requested that he ride with us while she did the show up.
Prior to the victim indicating that she recognized the victim, did her husband say anything like, "That's her," or did he identify her before the female victim said anything?
No, he said you can't recognize her from the clothes or can't recognize them from the clothes. And that's as we were driving past. He's like, is that them? And she said, I don't. And then he's like, you can't recognize from the clothes. And she said that she needed to turn around. So there was no recognition from him prior to.
Did he ever make statements about his knowledge about the suspect?
Yes.
When was that?
We were going through property that had been located and on the suspect at the time of being detained. And we found a Jeep car key. And the husband then said, oh, I think I know who this person is. And it was all in relation to having found a Jeep car key.
And how did he say he recognized the suspect?
He said that he had interviewed her for an in-home massage therapist position and had elected not to hire her.
Did he indicate how much earlier that interview occurred before this burglary?
I believe it was in January.
Okay, so like in
3 months.
So like in mid-January 2023?
Yes.
Okay.
Ms. Becker, brief argument.
Thank you, Your Honor. In this case, the witness did have the opportunity to observe the criminal at the time of the crime. She did provide a detailed description on the 911 call. The main change here is that she described the individual as being either Asian or Hispanic. I think it's very clear that Ms. Mayberry is African American. The 911 call did indicate that she was wearing an N95 mask, but I do think that that would sort of probably be the reasonable explanation for the difference in race. Otherwise, she was described as having worn all white that day. As seen in Peoples 3 and 4, she is clearly dressed all in white. She also has a white hoodie as described. She was contacted with items from the house that the victims recalled. And then, so the accuracy of the prior description was very accurate in this case. And then when the victim did view the defendant, she was very certain that that was the person she had just seen in her office. And the time between this was only 30 minutes, so it was a very short period of time. So for those reasons, I would ask that defense's motion 10 be denied.
All right, thank you. Ms. Mayberry, any argument you wish to make?
Yes, I would like to make a statement. Your Honor, I respectfully appear today by special limited appearance as the living woman, Michaela Jean Mayberry.
Now here's where the stakes jump dramatically. This second defendant isn't just arguing theory, she's facing felony burglary charges. And unlike traffic offenses, these carry real prison time. Showing up an hour late for a motions hearing when you already have a history of failures to appear is the fastest way to lose your freedom. Judges don't revoke bond lightly. They do it when a pattern forms. And this case already includes extradition from another state, violations of protection orders, and prior non-compliance. This isn't about jurisdiction anymore. It's about accountability. 222222222222222. This moment is devastating for the defense. The judge revokes bond and issues a warrant based on documented history, not emotion. A $20,000 cash-only bond tells you exactly how seriously the court views the risk here. Cash bonds exist specifically because courts don't trust the defendant to return. And notice something important. None of this would have happened if she had simply arrived on time. Sovereign citizen beliefs don't stop warrants, don't cancel bonds, and don't override criminal history. Reality always catches up, and it does so fast.
I do need to say this on the record. For my fundamental understanding, and I speak them in good faith and honor. I'm here today in proper persona, not first pro se, not as a defendant, not as a surety. I'm not representing a legal fiction. I do not voluntarily submit to any role presumed upon me under administrative titles or statutes. I reserve all my rights without prejudice under UCC 1308, and I demand that none be waived knowingly or unknowingly. Do not consent to any contract or jurisdiction not fully disclosed and agreed upon. Notice has already been served, including IRS Form 2848, Form 56, formally revoking all presumed power of attorney and fiduciary relationship that may have been assumed by this court or its officers. I do not consent to joinder with any corporate entity bearing my name in all capital letters, and I'm not entering a plea. I respectfully stand on my rights. I do not consent to being administrated. I am not here to disrupt. I am not here to argue. I'm here to preserve the record and speak my truth in peace, and request that no adverse inferences be drawn from my silence or non-participation in assumed procedures. I respectfully request that the court intends to proceed to produce on the record a verified claim by a living injured party, a lawful contract bearing my signature, and a proper delegation of authority granting this court jurisdiction over me as a living woman. If this court does not possess those items, I ask that this matter be closed and settled honorably. I do not consent to incarceration, coercion, or compelled contracts. I thank this court for honoring my peaceable notice and my appearance.
If I could just have confirmation from Ms. Mayberry that she's received my emails on the record, then I know that that's a good email for further communications for sending the witness list and exhibit list and instructions.
Ms. Mayberry, have you received those emails?
Okay, Your Honor. No, I'm not the entity the court has created. I am Michaela of the Mayberry family. I am a living woman. And so let the record reflect that I object to any proceedings inconsistent with the Constitution of the United States and the Constitution of this Commonwealth. And I demand this tribunal apply the controlling constitutional doctrine and any action in contradiction to that is ultra vires and void.
Okay. Ms. Mayberry, did you receive the emails from the people?
Again, Your Honor, let the record reflect that I object to any proceeding inconsistent with the Constitution of the United States and the Constitution of this Commonwealth. I demand this tribunal apply the controlling constitutional doctrine, and any action in contradiction is ultra vires and void.
Ms. Becker, what I'm going to find is that the people received the email address provided by Ms. Mayberry on Tuesday, that the people have made good faith efforts to provide that information to her. Court has inquired twice of Ms. Mayberry whether or not she received the emails and would neither confirm or deny it, and has made a record accordingly. So I'm just going to make those findings. And anything else?
No, the people will continue using that email address on a good faith basis for providing that information.
All right.